really for the arbitrators to resolve the dispute under the main concession agreement, assuming the main concession agreement is the central agreement that is in play here, without looking at the Mama Bear agreement. And by doing that, does it then mean that it is the Mama Bear agreement that controls the dispute?
Yes, Your Honor, that's correct. We have cited cases in our briefs, the Moritz case, the Bank of California case. You have to look at the substance of the dispute. Merely mentioning another agreement that has an arbitration provision does not make the dispute arbitrable. The facts here are undisputed. There are several agreements, again, as I mentioned, one with an arbitration provision, one with not. But there was one drawdown, which was pursuant to the Mama Bear agreement. All of the parties agreed to that. The Superior Court and the arbitration panel recognized that, although the arbitration panel then went against that later in their findings. But all of the parties agreed that the drawdown was done pursuant to a breach, an allegation of a breach by the Mama Bear agreement. And there is one letter of credit that covered all three agreements. The letter of credit was amended in 2007 in order to include the Mama Bear agreement. In order for the arbitration panel to decide whether the airport was entitled to draw down the entire amount of $2.1 million, it had to look at the surety provisions. It had to look at the Mama Bear agreement. It had to look at the provisions of the holdover provisions, the amendment, et cetera, of the Mama Bear agreement. What the arbitration panel did is they recognized all of those facts, which we stipulated to, and then they manufactured this dispute under the main agreement in order to retain that jurisdiction and make an award. So at the end of the day, we're always talking about the Mama Bear agreement because that's where the dispute arises. There was no breach of the Mama Bear agreement, again, or any dispute under the main agreement without that dispute under the Mama Bear agreement.
But the dispute as framed by DFS, I understand, there's a disagreement, is that the breach had to do with utilizing the performance bond that was specified under the main concession agreement. And as pointed out, in terms of you even pointed out, there's been no allegation of any breach on the part of DFS under the main concession agreement. And in reference to the nature of the dispute, doesn't that have to do with the amount that was drawn down from the funds that are seemingly allocated under the main concession agreement?
Well, Your Honor, just to take a step back, that LOC again was a single LOC that covered all three agreements. So yes, the main concession had X amount that was allocated to it, and the Mama Bear agreement had X amount that was allocated to it. But there was also the Baby Bear agreement, which had $250,000 also allocated under the LOC. So you have one pool of money. So I point this out because I think that's one fact that demonstrates that the arbitration panel had to reach in order to find this dispute under the main agreement, because it was one LOC. How could they find that the entire amount was allocated to the main agreement when it was also covered the Mama Bear and the Baby Bear agreement? And if the court reviews the arbitration panel's findings, I think it's pretty clear that they had to look at the provisions of the Mama Bear agreement in order to resolve this dispute. And Your Honor, if I may, in paragraph 76, they determined that the disputed funds in the LOC were not available to the airport for breach of any agreement other than the main agreement itself. I mean, they're explicitly finding that it's not available for the Mama Bear agreement. They determined that the airport drew down on the funds pursuant to the main concession agreement and not the the Mama Bear agreement, which was contrary to the stipulated facts, where the parties agreed that the drawdown was done pursuant to the Mama Bear agreement. And lastly, the arbitrators made rulings regarding the Mama Bear security provisions, which they interpreted to mean that the airport was limited to drawing the $250,000 on the LOC for the breach of the Mama Bear, and therefore that the funds that the airport drew down over that were subject to the arbitration claims. Again, despite the fact that there was also amounts allocated to another agreement.
Well, you've asked me to step back, and so we can even step back further.
Okay.
And in reference to what this whole thing is about that's in front of us. I mean, we're not here, I don't, at least in my mind, to litigate and sort out the facts. And the parties, if the main concession agreement is what is at issue here, called for arbitration. And the issues of arbitrability, we don't have to go through the various steps in reference to who determines it in the first instance as to what issues are arbitrable. And the arbitrators, looked at the various arguments. They looked at read the briefs, I assume, and decided that the main concession agreement was the agreement that was breached, and that and it made its rulings. And so, as we said, we're not going to make new law here. There are specific standards in reference to when a court steps in to vacate the decision of the arbitrators under very limited circumstances. So isn't really that where we're at in reference to this case?
No, Your Honor, I disagree. Yes, we recognize that the review of arbitration decisions are under limited review, but courts will step in, and we've cited a number of cases where parties do not agree to arbitrate a dispute. Most recently in 2022, I believe the United States Supreme Court came out with the decision entitled Morgan versus Sundance, where they clarified the policy favoring arbitration. And what they said is they're not trying to put arbitration over litigation. What they're trying to do is honor the parties' agreements and the parties' intent. And we would submit that the airport never agreed to arbitration. That's where the fundamental dispute is, right? That we did not agree, the airport did not agree, DFS did not agree to have the Mama Bear issues resolved in arbitration. And the fact that the arbitrators got where they were and our arguments that they exceeded their jurisdiction by looking at the Mama Bear dispute is further exemplified by the Superior Court's decision confirming that award. This court also has to, what we're here is the court is reviewing the Superior Court's decision in order confirming the arbitration panel. So the court still has to look at the decision, right? It doesn't get to skip past that just and look at the arbitration award. And the Superior Court itself recognized that it had to look at the Mama Bear surety provisions in order to decide the dispute that DFS created. And I want to cite page 9 of the decision in order, where the Superior Court explicitly says, the crux of GIA's first argument rests in the question of whether GIAA withdrew funds from the Citibank LLC strictly under the terms of the Mama Bear agreement without disturbing the main agreement. Therefore, the court's inquiry starts with an examination of the surety bond of the Mama Bear agreement. So the Superior Court itself recognized that in order to decide the question of whether the airport was entitled to withdraw that full amount, the court recognized that it had to look at the Mama Bear facts, that it had to look at the substance of the dispute rather than this mere assertion that this was a claim under the main agreement.
I think I agree fully that Superior Court could have been a little more careful in its choice of language when you consider the outcome that where it came out. And but this is a de novo review. We get to review the contentions under that standard of review, both the Superior Court decision and the arbitrator's decision is in that the standard of review that's applicable to us in reference to our review of the case.
Well, yes, Your Honor, it's de novo, but I guess what I'm getting at is that the Superior Court demonstrated out loud that this arbitration panel was reviewing questions and issues that it did not have jurisdiction to review. And it went through a full examination in its decision and order. And that's what we argued to the arbitration panel. That's what, we argued before the Superior Court, that you cannot get to where you're getting. You cannot get to a determination that the funds were not available under the main agreement unless you actually look at the facts surrounding the Mama Bear Agreement, which the arbitrators did not have the jurisdiction or the power to look at. And as your Honor mentioned earlier, there is a government claim that is pending before the Superior Court. That claim, in DFS's claim, they have alleged the same allegation or assertions with respect to the drawdown, that the airport was not entitled to draw down over $250,000 above the Mama Bear security provisions, and that it was a breach of the Mama Bear Agreement when we did
But
did so.
DFS conceded that issue is left for the government claims action, and that result was reflected in it not contesting that 250,000 of the amount drawn down was not before the arbitrators, and the arbitrators accepted that.
Well, yes, Your Honor, but what I'm saying is that they have the same claim in both proceedings. They made that assertion in the Government Claims Act proceeding, and they made that assertion in the arbitration proceeding. So now what the airport is left to face with is two inconsistent decisions, where you have an arbitration panel that's saying the airport could not draw down 1.8 million or the amount above the 250,000. And then you have an agency decision, the airport's decision, that we were entitled to draw down the full amount. And that decision is still pending before the Superior Court. It's consolidated with this action. It has not moved forward in 7 years, despite the fact that we have filed a motion to dismiss for failure to prosecute. The court hasn't made a determination in that case, but it has made a determination in this case, which we would submit is the wrong case in order to review. The airport or DFS recognized that there was a process, which is the Government Claims Act, to get this dispute resolved under. They followed that process, except they pushed the arbitration proceeding forward at a more vigorous pace, and have, for the last few years, try to push this before its government claim got resolved. So now we have a decision that's pending out there that is contrary to this decision. The Superior Court has not reviewed it. And so, what we have argued is that effectively this arbitration panel exceeded its authorities by reversing the government's decision, which it did not have the authority to do. The Superior Court has the authority to do that. And therefore, now we're left in a position where DFS is seeking remedies and damages above what it would be entitled to under the Government Claims Act. That's also part of our appeal, that the arbitration panel exceeded its authority when it awarded attorneys' fees and interest, which is explicitly prohibited by the Government Claims Act. And that for that reason, that the award should also be vacated. So, Your Honor, did you have any questions?
Counsel, just for my benefit, can you conceptualize for my benefit? Is the main agreement separate from the Mama Bear, or is it the Mama Bear subset of that main agreement?
They're separate agreements, Your Honor. They're separate agreements and separate spaces. The main concession space, was a larger space at the airport.
I'm not talking about space. I'm talking about the contract itself.
They're separate. They're separate.
So you're asking this? Okay. All right. I think that answers my question.
Okay.
Yeah.
Let me, okay, you have, I don't know how much time you reserve.
I reserve 10 minutes, Your
10
Honor.
minutes, okay,
Yeah.
I'll let you reserve the remaining time if
Okay.
that's your decision at this time.
Yes, Your Honor. Thank you.
All right, okay. And Mr. Sa, you are recognized.
May it please the court and counsel. This case we would submit as a simple one. The question posed to this court is narrow and the law is well established and clear. And in particular, the law governing the confirmation of arbitral awards, which points to the only appropriate result in this case, which is confirmation, is not only black letter in Guam and in the rest of the United States, but also in the overwhelming number of countries in which international arbitrations are conducted. And this was an international arbitration. And the reason for that overwhelming concurrence in the law favoring the confirmation of arbitral awards is clear. Without such a set of black letter rules, arbitration would devolve into nothing more than what the appellants would want it to be, a ceaseless litigation and relitigation of the factual issues and determinations that the parties gave to the arbitration panel to decide. I think it's noteworthy that appellant's presentation began with a lot of comments about cases not this one. And I'm not going to address any of those except to say we disagree with that mischaracterization, and we're just going to move on. I think what we can focus on are that the critical facts here are either stipulated to or not really disputed. And let me run through those very quickly because they help drive this discussion. Number one, the GIA never contested the validity of any provision of the main agreement. In fact, in other litigation, it's asserting rights under the main agreement. Number two, the GIA has never contended that DFS breached any provision of the main agreement. Number three, in the main agreement, the airport and DFS agreed to a broad arbitration provision, which gave the panel, the arbitral panel, jurisdiction to decide any dispute, claim, question, or disagreement arising from or relating to the agreement or a breach thereof, which by its broad definition would include the court's jurisdiction and arbitrability. But more specifically, in that arbitration provision, the airport and DFS also agreed that the dispute would be settled by the AAA's rules, commercial arbitration rules. And in the commercial arbitration rules, the AAA gave the panel the power to rule on its own jurisdiction. That's the rule 7A. Next, when DFS initiated the arbitration, the airport fully participated and litigated the issues presented. And in fact, early in the litigation, before the final hearing began on January 20th, the GIA filed a motion to dismiss on the ground, the same ground that the panel lacked jurisdiction that is before the court today. And we're going to take a look at that, the language in that motion to dismiss order, which is very instructive. Next, it is undisputed that after considering the airport's jurisdictional arguments, the panel decided against the GIA, finding that the panel had jurisdiction and denied the airport's motion to dismiss. The airport did not challenge that denial, and then the case went to full panel hearing over 2 days from February 23rd to 24th. The airport and DFS fully litigated the final arbitration hearing, during which both parties presented extensive witness and documentary evidence. And during the course of the final arbitration, Your Honors, the GIA defended the arbitration again on the very same grounds that are before us here today, this jurisdictional argument. It is undisputed again that the panel again considered the airport's defenses and again ruled against them, and then issued a final 16-page award. So what are the undisputed legal principles that we apply to this set of facts? First, it is undisputed that the Supreme Court's review is extraordinarily narrow and does not involve a review of the merits of the party's dispute or a review for panel error, even serious error. As was said in Sumitomo, if an arbitrator is even arguably construing or applying the contract and acting within the scope of his authority, a court's conviction that the arbitrator made a serious mistake or committed grievous error will not furnish a satisfactory basis for undoing the decision. The United States Supreme Court has made clear the same, saying specifically in Shine versus Archer and White Sails.
The whole contention of GIA is that this is the case where the arbitrators exceeded their powers. And so you would agree that if that contention is correct, that would be one of the limited grounds where this court can cite the arbitration decision.
Yes, Your Honor, understood. And perhaps with that, I would turn to that very issue. I do think it's helpful, however, to frame up that issue within the applicable standard of review. First of all, we start out with the fact that there is this quote jurisdictional argument is not about a dispute about the panel's jurisdiction to resolve issues under the main agreement. Okay, the quote jurisdictional argument is an argument that there was comment as to the Mama Bear agreement, and therefore they have exceeded their jurisdiction. But there is no dispute that they had jurisdiction to rule on the main agreement issues. If you look at all the cases that they cite where their arbitral decisions have been reversed, though that is the kind of case that arises. That is, that the arbitrators decided something, ruled on something on the rights and obligations of the parties before it, or maybe not even before it.
But if the airport is correct, that the agreement that is applicable here is the Mama Bear agreement, then the dispute would have no business being before the arbitrators in the first instance. Would that contention be correct?
If
the Mama Bear agreement was the applicable agreement to resolve the dispute as to whether or not the amount drawn down above 250,000 was the applicable agreement in reference to the dispute of the parties.
Your Honor, I think, as I understand the question, the simple fact is that there was nothing that was decided in this arbitration award that impacted the Mama Bear agreement. The Mama Bear agreement dispute is ongoing, as the court pointed out. It's been languishing. Actually the airport filed its claim for declaratory relief, which covers all of the remedies they would like under the Mama Bear agreement. And they have let it languish. It has been sitting there since 2014. The truth of the matter is that there was nothing that was in the arbitral award that defined the rights and obligations under the Mama Bear agreement. They are fully able to litigate every single issue under the Mama Bear agreement. We have invited them to do so. There is nothing that the arbitral panel did that would restrict a right or obligation. And that is the key issue here. I mean, when we first tried to puzzle through exactly what they were saying, this analogy came to mind, okay? And perhaps this will be helpful. Let's say you have an agreement with your contractor. You're a homeowner. Homeowner has a contract with a contractor to renovate his home in the amount of $1 million, okay? So there's a contract. Now the homeowner and the contractor get into dispute over the $1 million. The contractor feels that $1 million is owed to the contractor. Because the contractor has a key, the contractor goes into the homeowner's house and steals a vase, very valuable vase, worth $800,000. The homeowner brings an action, return my vase, okay? Return my vase. You took my vase, you didn't have a right to take my vase. That does not mean the returning of the vase has nothing to do with the underlying contract. At the end of the day, contractor might be right. Contractor might be right that the full $1 million is owed. But contractor was wrong to take the vase. And that is what this arbitration was about. That is what it was limited to. And that is what the panel said over and over and over. It said
So counsel, the same question I asked the opposing counsel. In your mind, conceptually, the main agreement and the Mama Bear agreement are two separate agreements?
They are not just in my mind. I think everyone is in agreement. They're two separate contracts.
So where does how do you have a nexus?
The arbitration agreement sits in the main agreement. The Mama Bear agreement has no arbitration provision in it. The Mama Bear agreement is subject now to current ongoing litigation before the Superior Court, in which the airport is entitled to and may make every single argument it wants.
Do you need a language in the Mama Bear agreement that says, notwithstanding the main agreement, this will not be resolved through arbitration? Do you need something like, if it's silent, how do you connect the two, if it can be connected at all?
Your Honor, I think the best answer for your question is simply that they are two separate contracts with two separate rights. The claim that the airport is making is that $2 million+ are owed for holdover rent under the Mama Bear agreement. Fine, they can make that claim. Let's litigate that. The issue that we brought is you stole my vase. You took money that was set aside for the main agreement to which you had no right, and we have a right to arbitrate that. Return the vase. That's what this case is about. And actually, by the way, the panel was really onto this issue. The panel specifically noted that the drawdown, there was an initial drawdown attempt on the Mama Bear agreement, okay, of the full amount. That was rejected by Citibank. Citibank rejected that, okay? That's in the excerpt of record 242, 243. And then they reissued the drawdown under the main agreement. So in the arbitration award, they specifically recognized that it was going to be drawn down on the main agreement. And so the case then proceeded solely under the main agreement.
If in the situation with the first request of the drawdown by GIA, had Citibank honored that drawdown, and that was seemingly drawn down per the Mama Bear agreement, and if the dispute had proceeded under that scenario, would the result have been different, or the process different?
I think we would certainly have a different case, Your Honor, but that's not what happened. That's not what the record is here. And in fact, what is really noteworthy, and I would draw the court's attention to this, is there was an effort by the airport many times to interject the jurisdictional issue, this Mama Bear issue, into the main agreement, okay? That is what we are, the panel, the arbitral panel, was entitled to, and it was appropriate for them to consider the defenses raised by the airport and to reject them. That is an entirely appropriate thing. If not, then candidly, any party who is seeking to get out of arbitration could do the same thing. They could say, well, there's this issue and there's that issue. And then the panel could say, oh no, that doesn't apply here. And after saying not only does it apply, they could turn around and say, aha, you ruled on something outside of the scope of your jurisdiction. This would be an utterly fictional construct. But to really highlight the cynicism that is going on here, in the arbitration, the airport sought to file a counterclaim and offset, specifically trying to interject the Mama Bear agreement into the main agreement, okay? And I would turn the court's attention to the supplemental excerpt of record 142 to 144, because there you can see that the panel's order denying the motion to, granting the motion to dismiss the counterclaim and offset for the very reasons we're talking about. The panel said, we don't have jurisdiction over that. DFS filed a motion to dismiss the counterclaim because we didn't believe that the panel had jurisdiction, the arbitral panel had jurisdiction to consider the Mama Bear issues. We thought that was, we have tried very, very hard to keep it very clean. We didn't seek the whole $2.1 million, right? We deducted the $250. We just brought the $1.8 million underneath the main agreement LLC. And when the panel ruled on our motion to dismiss the counterclaim, this is what the panel said at paragraph 17. Furthermore, while airport argues that the potential return of funds to DFS in this arbitration is a mere procedural matter that will not resolve the disputes between the parties, DFS asserts that the loss of these funds is a substantive right to which is entitled to prevail. That's exactly what's happening here, right? They themselves, they were saying, in trying to interject the Mama Bear issues into the arbitration, they were saying, this is just a procedural issue, that it's not going to ultimately resolve the disputes, and therefore we should be allowed to bring this in. We said no. And all we were saying is that the time value of that money, of that seizure, is of value to us. Return the vase. That's what the case is about. Return the vase. You're not allowed to just simply self-help your way in whatever manner you wish and then try to interject the underlying dispute to try to justify self-help. That's the very essence of I think lawlessness, right? I mean, we have a process. If they brought a claim, They should have pursued it. We're happy to litigate that claim. But they haven't.
There are provisions governing the surety, in both agreements, correct?
I'm sorry, I don't think I understand your question, Your Honor.
There are provisions governing the surety that appear in both the main concession agreement and the Mama Bear agreement.
I believe so. I don't know which ones you're referring to.
So mine's a general question. Does that mean that the consideration of what the surety provisions are is necessarily governed by the main agreement? Or isn't it governed by both agreements?
The question of, first of all, let me start with this, which may help make this simple. The parties stipulated that the performance bond for the Mama Bear agreement was $250,000. Okay, so you don't even have to go to the underlying agreements. We can, but we stipulated, airporting we stipulated $250,000. So what the panel decided is, in connection with the very fact that the direction to Citibank was to give them the 1.82 some odd million dollars pursuant to the main agreement, that it was a dispute governed by the main agreement. So, I mean, I know it's quite simple. It's like the letter of credit for the Mama Bear agreement is only $250,000. They sought to draw $2+ million. Even then, we only sought 1.8 plus million dollars. Just the amount, arguably giving them credit for $250,000 under the Mama Bear agreement.
But wasn't the rationale is that there was nothing in the agreements that allocated the single LLC for, well, 3.65 million, that 250,000 goes to the Mama Bear agreement, 3.3 goes to the main concession agreement, and the other 250 to the Baby Bear agreement. There was no clear delineation of how these funds were broken down, other than what the agreements specified was the performance bonds in each agreement. I mean, that's why we're here today.
Right. Well, again, I don't know what the exact language is off the top of my head, but that is my understanding that. But again, what we are looking at, I mean, leave the Baby Bear out of it because it has nothing to do with this. But between the main agreement and the Mama Bear agreement, the parties agreed that the LOC for the Mama Bear agreement, since it's a much smaller space, was only $250,000. I mean, I don't know that we need much more than that.
Well, I mean, the performance bond for the smaller space had to do with the duties and responsibilities under the Mama Bear agreement. I know we're getting into the weeds here, and so the contention in terms of what was breached was the rental payments. In this case, liquidated damages were owed. So the fact that only $250,000 is specified doesn't necessarily mean that that's the only damages that can be recovered under the Mama Bear agreement.
Absolutely, that's right, and that question is before the Superior Court. Now I think I better understand your question, Your Honor. That all of the issues of how much the operation of the surety under the Mama Bear agreement, all of those issues are live issues. They are all live issues. The Superior Court is entitled to rule on them. And there is no risk of inconsistent judgment, by the way. We keep on hearing this, but that's not true. The arbitral panel only made decisions with respect to the main agreement. The Superior Court can come and make a contrary conclusion with respect to the Mama Bear agreement. They are two separate agreements. They are, right? So the Superior Court, they're entitled to make this argument about, well, it's a big pool, you can make a successive draw, whatever they want to make. They're entitled to make it because that's part of the mama bear dispute. And they tried to interject the mama bear dispute into the arbitration and we said no.
Well, also, I mean, if there is no dispute that has to do with the main concession agreement, then we never get to, or the case should never get to the main concession agreement. I mean,
That's right.
if the only issues stem from the mama bear agreement, the arbitrators can do all they want, but if they dispute never should have reached the or as derived under the main concession agreement, then the arbitrators would have acted beyond its powers in resolving a dispute that never should have reached. I'm not saying that that's the case here. I'm just trying to follow the arguments.
If it were true, which it is not, that the arbitral panel came in and said, I am going to decide rights and obligations underneath the mama bear agreement, and here they are. Yes, that is a significant problem. But instead, what did they say? In analyzing this question, the tribunal does not consider the validity of any claim under the mama bear agreement or the baby bear agreement, but refers to these agreements only tangentially as they may relate to the interpretation of the rights and obligations of the parties under the main agreement. The focus of the tribunal's analysis is on the main agreement itself. And it specifically disclaimed in the award, nothing in this award shall be construed as a determination of any rights or obligations under either of these two agreements, referring to the mama bear agreement or the baby bear agreement. The panel went out of its way to say, we are not impacting those rights and obligations. We are telling you we are not. What the panel was doing was entertaining the very issues we are litigating over and over again, which is that somehow that they have impacted the rights of the mama bear agreement, which they haven't. It would almost be, in this instance, for example, in the parallel situation, if the Supreme Court was entertaining these arguments and arguably didn't have jurisdiction over the mama bear agreement, arguably, that the same allegation would be made of you. Oh, you're now considering these arguments that are being made, and therefore you're stepping outside of your jurisdiction. All the context of this is extremely important. It is the airport that was interjecting the mama bear agreement over and over and over. That was their prime defense on a motion to dismiss. They try to bring it as a counterclaim and offset. They try to bring it in, and instead the panel was saying, no, we are not deciding any of these issues. They are two separate agreements. You have an ongoing litigation, go litigate it. And we're ready to litigate the other case. It's to me, again, it's where we started this discussion. We feel like this is a very straightforward issue. Just return the vase. That's all it's about. We can litigate whether or not there's a dispute over the contract, the underlying issues. Let's do that. But this is about improper self-help for an agreement that, even the parties agree. The LOC was only $250,000. How can you seize, over $2 million? So.
But just in that point, there's nothing specifically in any agreement that says that the amount that can be drawn down under mama bear agreement under the performance bond is limited to 250,000, subject to be replenished. There's nothing in the agreement.
I don't believe so, Your Honor. Again, it's been a while since I've looked at it for exactly that way. Maybe I'll be corrected in a moment here, but I don't believe so. But again, whether or not there is or not, these are factual determinations. By the way, these factual determinations were put before the arbitral panel. Let's be clear. If you read the award, you'll see that these very issues were raised, and the panel decided, at least as to the extent that, again, we would apply their factual determinations on the standard of review that, you have to establish manifest error. But again, Your Honor, I mean, I think to us, the clearest and most straightforward way to look at this is.
I guess there would be, in thinking about it more, a distinction and a significance, because had there been such a provision that there was no limitation, then there would have been no breach under the main concession agreement, and therefore and if there's no breach under the main concession agreement, then arbitration, then the remedial provision under the main concession agreement is not called into play.
Yeah, that's entirely correct, Your Honor. And again, with respect to the exact language of the Mama Bear Agreement, I've just been informed that the Mama Bear Agreement, of course, stipulates that the LOC is no more than $250,000. But in some ways, that's entirely subsumed by the fact that the parties agreed that the LOC, it's in a stipulated facts that the parties agreed it's no more than $250,000. So I just don't. I find that the arguments raised here, just are flatly misconstruing what occurred and what the applicable law is. I mean, when we looked at all the cases that were cited by, I only have a few minutes left, so I'm not going to go into each of them with specificity, but there's only three cases in which arbitral decision was reversed on a confirmation, and those involved very, very different situations where the agreement specifically said what you can and cannot do, and then the arbitrators stepped outside of it. It was a very specific thing and ruled on the rights and obligations on the very thing that they were not permitted to. And that is just not the situation here. The situation here is exactly the opposite. The panel went out of its way to focus only on what was before it, disclaiming ruling on anything else, but rejecting the meritless contentions, because what other position would the panel have? They couldn't simply sit mute while these jurors, while they were raising these arguments. They had to be able to say, I believe as the court recognized during appellant's argument, there has to be some at least response. And that's exactly what the panel says. Like, it's a tangential observation about a defense raised, and that's it. And with respect to everything else under the Mama Bear Agreement, they're entitled to litigate those things. Those are untouched. Still, to this moment, they still have not identified a right or obligation that is impaired at the Mama Bear litigation state. They still haven't done it. And I'll say this much: nothing in this argument would ever. We don't have anything to come and say, oh, the arbitral panel ruled this or that, because the reason is the rulings on the arbitral panel were with respect to the main agreement. They were with respect to the main agreement. The Superior Court is entitled to make different decisions about the Mama Bear Agreement. That's fine. That's what we expected. That's why we have two separate cases ongoing.
Is there anything else, Counsel?
You know, the opposing counsel mentioned about the government liability. What is your general position in regards to the attorney's fees?
Oh, yes. I'm glad you asked. By the way, I left very little time for fees and interest. I think the overwhelming law is that fees and interest in this case are appropriate. We've cited it. I think our briefs are straightforward. I'll tell you just in summary with respect to fees and interest. Section 13.5 of the main agreement especially provides for the prevailing party to receive its reasonable attorney's fees. The AAA's rules specifically set forth, which both parties agreed to, right? Both gave the arbitrators the authority to award attorney's fees. With respect to interest, the AAA rules authorize pre and post award interest. That's Rule 47D1. And likewise, Section 42A 405 of the GIAC specifically permits interest on an arbitration award. The cases also that we've seen The Guam cases that deal with that fees and interest with respect to arbitrations is uniformly on our side on this issue, that the government, when it enters into a contract for to arbitrate a case, is governed by those provisions, and the Government Claims Act itself is not implicated. That's straightforward out of YTK2. So, Your Honor, we feel like those issues on fees and interest are straightforward and well addressed in our briefs.
I've never seen this 21-day provision. So where does that stem from under the best scenario for DFS?
I'm sorry, I couldn't hear you.
There's a request for payment within 21 days should DFS prevail. I said that's a time period that is new to me. And is there any basis for that if that is ever triggered?
Your Honor,
It's in your briefs.
yeah, Your Honor, I'm afraid you've caught me at the very end of this with one question I can't answer off the top of my head.
All right,
But,
that's fine, counsel. I appreciate the arguments.
We would.
And I know that your time is up.
Oh, okay.
And so thank you very much. And Attorney Rapadas, you have about 9.5 minutes remaining.
Thank you, Your Honor. So I want to go back to the standard with respect to arbitrations, again, recognizing that this court's jurisprudence, as well as courts around the United States, have recognized that the scope of review for arbitration awards is narrow.
I think part of the statements that Mr. Saw constantly drilled and drove home is Attorney Rapadas is that merely mentioning that a certain parts, in this case the Mama Bear Agreement, merely mentioning provisions does not turn the case to be about the Mama Bear Agreement, and that has some resonance.
Well, I would argue the same thing, Your Honor. Merely mentioning the main agreement doesn't turn this into a main agreement dispute. Mr. Suh, just to go back to the standard of review, we are not questioning the arbitrator, the merits of the controversy or their factual findings or whatnot. As a court recognizes, we are arguing that the arbitration panel exceeded its authorities by deciding Mama Bear issues. Now, Mr. Suh and DFS states that the arbitration panel, they did not comment on the Mama Bear Agreement, that it has no bearing on the government claims decision, that there's no impact. I mean, I heard a lot about that. But I think it was important for the Superior Court as well as this court to look at what the arbitration panel actually did. I mean, despite their disclaimers that they weren't looking at the Mama Bear Agreement, that they weren't deciding any issues under the Mama Bear Agreement, they had explicit language within the arbitration award that they were deciding disputes under the Mama Bear Agreement.
But if we were to drill down on that analysis and say, for example, in the provision regarding the performance bond and what is specified in the main concession agreement, there is also a provision that unless it's otherwise modified in writing. So I think if the arbitrators were looking at the main concession agreement, what is the performance bond say respectively, and in order for it to determine whether there's another writing that modified the main concession agreement, then wouldn't it be prudent to look at whether or not there's language in the Mama Bear Agreement that provided that writing that modified the agreement?
Your Honor, that's our whole point, is that they couldn't. I mean, it's not about whether they were prudent or not. I mean, they could not look at the security provisions or the provisions of the Mama Bear Agreement in order to decide a dispute that was created by DFS. I want to really go back to the facts, which is that there was one LOC for all three agreements, and that there were three separate agreements, and that the drawdown was pursuant to the Mama Bear Agreement, and the breach that the airport alleged was pursuant to DFS's holdover of the Mama Bear dispute. And there was also facts.
But what about the limitation that the performance bond under the Mama Bear agreement is only what was $250,000 and an amount up to $2.1 million was actually drawn down. How is it then that it just was limited to the Mama Bear agreement?
Your Honor, there's actually, I don't believe there's any explicit language that limited the airport to those amounts. Yes, there were amounts that were allocated per agreement, but there was no limitation as to how much the airport could draw down. And that's what the dispute is about. That's what DFS's government claim is about. But
not what the ultimate award is, but what was guaranteed to be paid under the performance bond. I mean, if the matter goes to litigation and $3 million is recovered, then it'll be an amount that will be paid over the 250. It's just what the parties specified was the guarantee under the performance bond.
Well, yes, I mean, the parties specified how much should be guaranteed under each agreement. But the provision, the contracts actually initially required that each of those agreements would have separate security. But upon DFS's request for their convenience, they asked the airport to have one agreement instead, have one LOC instead. And that's what the airport did. And at no time during those negotiations, and this is why we're talking about what happened when the parties amended the LOC. I mean, this goes to our very argument that this is a Mama Bear dispute.
Under which agreement was the amendment made?
Under the Mama Bear agreement. Under the Mama Bear agreement in 2006, the LOC was amended to by DFS in order to increase the amount for the security for the Mama Bear agreement. And then it was amended again in 2010 in order to secure the Baby Bear agreement.
So the main agreement was never.
The main agreement itself now was not amended, but the LOC itself was amended in order to increase the amounts.
But aren't the provisions governing the LOC in the main agreement?
Well, there's provisions in all three agreements with respect to the LOC. So each of the agreements have a provision requiring some form of security.
But the instructions for paying out?
Yeah, and Your Honor, I do want to address that. So that was evidence that was put forth before the arbitration panel as well, is that when the airport initially wrote Citibank to draw down on the amount, Citibank rejected it because it wanted they wanted the language of the original LOC. So that was a factual, those were facts that were presented to the arbitration panel that were not taken into consideration, but they should have been this is something that should have been litigated in the Government Claims Act, because DFS's government claim actually is also a claim for the entire amount, and that the airport wrongfully withdrew down the entire amount. So you have, again, two claims and two different proceedings. So I'm hesitant to fully go into all of the facts about the Mama Bear dispute because it was not before the arbitration panel. It wasn't proper for them to review it. But at the same time, it's imperative that the airport argue some of these facts to demonstrate why the arbitration panel exceeded its authority. And so, it's our position that basically DFS took a Mama Bear dispute, they hijacked it in order to obtain an award that is now probably double than what they would have received in the Government Claims Act. And again, just going to the arbitration award, I would.
Isn't that a risk the airport took when it didn't repay the $1.8 million?
Well, no, Your Honor, because we have a government claim decision which says we're entitled to that entire amount. So
You do? I thought you had
sorry, we have a decision on DFS's government claim that says we're entitled to the full amount, which has not been
But that was
decided.
issued by GIA.
Yes, but it's being appealed by DFS, and they have not pursued that government claim, that action. And Your Honor, Mr. Seth says that we'll litigate that issue. It's just about the vase, but what they're asking for is a vase that's fully refurbished and then some. They're asking for, hundreds of thousands in attorney's fees. They're asking for costs, all things that the Government Claims Act does not allow for. And there was mention of YTK. I mean, as your honors know, we are familiar with that case.
But I don't understand. I mean, these are collateral issues, but when you say that the government claims doesn't provide for, I mean, this is a contract dispute. And if in fact, the airport agreed to the arbitration provision and agreed to settle its dispute, I don't recall any provision in the government claims that prevents recovery of fees or interest in a contractual dispute. In a tort dispute, I think case law is clear.
Yes, Your Honor. And if I can quickly, I have about 10 seconds. I want to talk about Guam YTK for a little bit. I recognize in that case that the court didn't get to the ultimate question of whether the Government Claims Act precludes attorneys' fees and costs and interest when an arbitration award is involved. But I think that the court had important language about the power of the courts to vacate an award when the arbitration panel allows for remedies that the Guam legislature has expressly prohibited. And so I would ask the court to go back to its opinion and carefully review that it did provide some guidance, although it didn't decide the issue, did provide some guidance that even in an arbitration that these remedies are not allowed against a government agency. I mean, otherwise, why would a government agency ever agree to enter into, an arbitration if it was the other side was entitled to, attorney's fees, costs, and et
Because
cetera.
if the airport prevails, it would be entitled to its attorney's fees.
Well, Your Honor, I mean, again, the government claim, that's the same in the Government Claims Act as well. So.
All right, I see that your time is up.
I believe so, Your Honor.
All right. Thank you, Attorney Rapadas.
Thank you, Your Honor.
Thank you, counsels. The court appreciates the arguments. The matter will be taken under advisement and the court stands adjourned.
Thank you.